The issue of my recusal has arisen specifically in the context of the recent private prosecution of the lead prosecutor appointed by the state, Mr. Dana SC, and Mr. Zuma's request that I should remove Mr. Dana as prosecutor, all viewed in the light of findings and comments I had made in previous judgments in this trial. In an exchange of correspondence prior to the last appearance, Mr. Zuma's attorney in a letter recorded, "We are instructed to register our client's objection to any further involvement of Advocate Dana in this matter." At the last hearing, Mr. Zuma's counsel specifically requested that I rule mero motu on whether Mr. Dana could and should continue. I concluded that the intention by Mr. Zuma was that Dr. Mdujwa's letter of 8 August 2021, being the letter which contained the medical information, was to be used in support of Mr. Zuma's application for a postponement, which would mean that it was intended to become public in any event, as no confidentiality was claimed when the letter was filed in court as part of his papers, nor were any parts of the letter redacted. I further expressed the view that the letter had been disclosed to Mr. Dana, Ms. Naika, and the DPP of KwaZulu-Natal by the head of the Correctional Centre at Escort on 8 August 2022, who seemingly did not view it as a confidential letter either. In my view, the letter, I found, did not contain anything confidential. Indeed, I described the letter of Dr. Mdujwa to be vague and general in its terms, as it did not disclose any particularity and did not mention any specific medical condition or illness Mr. Zuma is alleged to suffer from. I accordingly concluded that the disclosure of the contents of the letter did not only not deprive Mr. Dana of the title to prosecute, but that he also should not be removed as a prosecutor. Finally, I concluded generally, in regard to all the grounds, that on the evidence before me, it had not been shown that Mr. Zuma's rights to a constitutionally fair trial had been impaired, or that there was a reasonable possibility that his rights would be impaired. An objective accused person in the possession of Mr. Zuma reasonably could not be expected to be satisfied, having a judge who has expressed views and made findings regarding the alleged leaking of his medical information by the prosecutor, now deciding, based on those very same facts which had been dismissed as devoid of merit, whether the integrity of the prosecutor has or has not been impaired to the extent that he should or should not be removed as prosecutor. Reasonably construed, my findings indicate that I have favored a particular interpretation of these factual issues, and they point to a reasonable and inevitable apprehension that when these facts and circumstances are presented before me again, they will be decided by me in a similar manner. I've come to the conclusion, and it was not an easy decision, that I have to recuse myself from the trial. It is what the sound administration of justice, the requirements of the Constitution, and my conscience dictate.